Lovers of freedom, good morning everybody. I just want to give you update with respect to what is happening. A few days ago, I made an update here when I was in Sokoto about respect to Nnamdi Kanu's well-being and the ongoing matter pending matter at the Court of Appeal. And I also told you that Nnamdi Kanu, of course, have decided to exercise his right under the Constitution to represent himself in his criminal matter at Court of Appeal, which is his fundamental right. And he's not the first person that is representing himself. People have been representing himself is the constitutional right given to him by the Constitution. So that he also demanded that the legal experts who cares should submit a contribution which they made. Of course, it is necessary. Nnamdi Kanu, not only that she is not a lawyer, even lawyers, when you are doing a matter, you normally call for opinion from your colleagues, not to talk about somebody who is not a lawyer. So he called for that everybody, if you have a draft appellate brief, you feel that you can adopt, you should come up with it. So I did my own. So I submitted to him and asked him to go through it. Where it was my own, I feel that it fall in line with the record of proceedings and the grounds of the appeal. So, and if you want that copy, it was not signed, it was not filed. I also posted it in my own page. This is what I submitted to Nnamdi Kanu for those of you who are not lawyers to see, to have an in-depth view, to have a clue of what happened in that particular judgment. Because if you read out my appellate brief, I illustrate a lot of things with respect to the decision of the court, fundamental rights, violation of his fundamental rights, and a lot of things that happened, which it was not signed, it was not filed. Nnamdi Kanu has not even adopted it, but I just brought it there. So those of you, of course, those the lovers of Nnamdi Kanu and the lovers of freedom, and those who cares to know, they give me a call privately and give me a private chat to get more explanations about what I posted. I explained to them, so I understood okay, and they thanked me and they appreciated the industry I put in preparing, analyzing and reviewing that appeal. So those of you, of course, is expected. Those who want to expose their ignorance of the law, those who want to exhibit their hatred against Nnamdi Kanu, jump into the page as usual and start attacking the person and start attacking my very self. But that one is not why I am here. Then why I am here this morning is to let you know that in the course of going through that judgment, I discovered that there are some things the judge said during the course of delivering the judgment that was not contained in the judgment. And thank God that the judge also ordered for that the proceedings of the judgment should be transmitted live. We have media people there, AIT was there, channels were there, Arise was there, and some other media houses were there. So in revealing the tape, the video clip, the things that the minor said with respect to the custodian where Nnamdi Kanu will serve his appeal was not contained. The thing the prosecution counsel said, the comments and the remarks the prosecution counsel said, I'm talking about Chief Awumolu SAN, was not also contained there. And the Nnamdi Kanu was not given an opportunity. Remember that he was bundled out of the courtroom. He was not also contained there. And most importantly, the reason the judge gave, the reason he bundled Nnamdi Kanu, and the reason why Nnamdi Kanu should not be served in Kuje, rather in Sokoto, was also not contained there. So there are some omissions in that particular judgment. So we have the clip, we have reviewed the clip. Now we are now bringing a motion challenging that particular record of proceedings and that particular judgment. Why should the judge and the court remove all those fundamental issues? Because they know that Nnamdi Kanu will use it to form part of the will use it as a grounds for his appeal. But be that as it may, we have I have filed and prepared a motion. This is the one I posted here, asking the court to compel them to complete that record and that judgment, and also to stay and also file an affidavit to be served to the judge and to the registrar of the court to come and explain the reason why they should not produce those omission. So that is why I say, let me just give you the update. For those of you who feel that you don't want to see anything that you don't want to see or hear anything that has to do with Nnamdi Kanu in the public domain, you are wasting time. We should be giving update, just like as we have a high demand of people calling Maxwell, what is happening by Maxwell. So we are not going to keep in that. We are going to be bringing it every update. So those of you who feel that you don't want to hear anything or see anything that has to do with Nnamdi Kanu, you can go and hawk transformer. But meanwhile, for those of you who are interested in what is going on with respect to this Nnamdi Kanu's matter, please remain focused. If you watch, the majority of people that attack Maxwell, attack Nnamdi Kanu's lawyer, attack Nnamdi Kanu are the people that the federal government is sponsored. And you will see them jumping from one social media to another. Even when you are not invited them in your page, they will continue. Even when you try to delete them, they will go and create another Facebook name to join you, to follow you. But we decided to allow them to continue to expose their ignorance and stupidity. Thank you and God bless you.
A lawyer named Opara went live, and what he said matters. Opara explained that Nnamdi Kanu, exercising his constitutional right to represent himself at the Court of Appeal, had called on lawyers and legal-minded supporters to draft appellate briefs for his consideration. Opara responded. He prepared a draft brief, submitted it to Kanu, and published it publicly on his own page. He was clear about what it was, a contribution, not a filed document. It was not signed. It was not stamped. Kanu had not adopted it. He published it so that ordinary Nigerians could read it and understand what grounds exist for challenging the judgment. Many people reached out privately, thanked him, and asked for further explanation. Others attacked him on social media. He dismissed that entirely and moved on to the real reason he came online that morning. The discovery. While comparing the written judgment against video footage of the actual court proceedings, footage recorded by television stations present by the judge's own order, Opara found serious gaps between what was said in court and what appeared in the official record transmitted to the Court of Appeal. He identified 4 specific omissions. 1. The judge's stated reason for ordering that Kanu be detained specifically in Sokoto State was absent from the written record. 2. Remarks made by prosecution counsel during proceedings were missing. 3. The fact that Kanu was physically removed from the courtroom without any lawyer present to represent him, while the judgment continued in his absence, was not documented anywhere in the record. 4. The reasoning behind the Sokoto transfer, which the judge stated openly in court, did not make it into the official document sent upstairs to the appellate court. Opara put it plainly, these things were said in open court. They are on tape. They are simply not in the official record. Why it matters? The missing portions are not random. Opara said they are precisely the portions Kanu would rely on as grounds for his appeal. Proceeding with judgment while the defendant had been removed from court without legal representation is a fundamental rights violation. The judge's reasoning for the Sokoto transfer is a justiciable matter that an appellate court is entitled to examine. Prosecution remarks form part of the record of proceedings and must be included in any legitimate transmission to a higher court. Opara's conclusion was blunt. The omissions were not accidental. The court removed those portions knowing they would form the strongest grounds for Kanu's appeal. The motion filed. In response, Opara filed a formal motion asking the court to compel production of a complete and accurate record. An affidavit has been served on both the judge and the court registrar requiring them to appear and explain why those specific portions of the proceedings were excluded from the record transmitted to the Court of Appeal. Either the record is completed, or those responsible must answer for its incompleteness. The Sokoto transfer. Opara then turned to the transfer itself and questioned it directly. Nigeria has 36 states. Lagos, Enugu, Abeokuta, Abuja itself, none were chosen. The government selected Sokoto, a state contending with active terrorism, insurgency, and banditry. He drew one comparison to make his point. Individuals convicted of terrorism, including those with al-Qaeda links who stood in court and confessed to killing countless people, received 10-year sentences and were held in Abuja, not in Sokoto, in the capital, comfortable by comparison. If violent conduct is the government's stated justification for sending Kanu to Sokoto, Opara asked, why were confessed mass killers given shorter sentences and better conditions at the seat of power? He answered his own question. This is not law, it is interest. The federal government's decisions in this case, from continued detention to the choice of facility, are not driven by legal principle. They are driven by politics. The transfer to Sokoto, he said, is a deliberate message, a signal of which power structure holds dominance in Nigeria and a reminder to Kanu and those who support him of exactly where they stand within it. The final word. A second voice on the broadcast added the necessary context. Nnamdi Kanu had previously been discharged by an appellate court. He had been granted bail by a federal high court. Both outcomes were subsequently reversed or overtaken, every legal win undone. That pattern, the commentator said, led him to one conclusion: the Nigerian courts are not the final authority in this case. Interest is. And until that changes, no motion, however well prepared, and no ground of appeal, however strong, can guarantee that justice will be the outcome. He said he had made peace with that reality. He knows Kanu will eventually be released. What he no longer has confidence in is whether it will be the Nigerian courts that release him or something else entirely. This is AfriSite Forum. We report what was said. You decide what it means.